I think we should start now. The number of participants as compared to registrations is less, but I think it's still 10 minutes above time, so I think we should start now.
Sure. Bismillah ar-Rahman ar-Rahim. Alhamdulillah Rabbil Alameen. Wassalatu wassalamu ala ashrafil anbiya'i wal mursaleen. Nabiyyina Muhammadin wa ala alihi wa sahbihi ajma'een. Excellencies, distinguished guests, my brothers and sisters, Assalamu alaikum wa rahmatullahi wa barakatuhu. And a very good day to all of you joining us from different parts of the world. On behalf of Accounting and Auditing Organization for Islamic Financial Institution and its partners for this particular public hearing, KNEKS from Indonesia, INCF ISRA RMC from Malaysia, Salihin Shari'ah Advisory from Malaysia, and other advisory from Malaysia. We welcome you to this very important public hearing session on an important standard issue, on an important exposure draft issued by AAOIFI Governance Board, AAOIFI Governance and Ethics Board. The standard is on Sharia compliance and fiduciary ratings of Sukuk and other Islamic financial instruments. It is a continuation of an earlier standard that AAOIFI Governance and Ethics Board had issued. We call it AAOIFI GS10, Sharia compliance and fiduciary ratings of Islamic financial institutions. The standard intends to promote Sharia compliance and fiduciary ratings of Sukuk and other Islamic financial instruments. It sets out the minimum requirements and defines the approach and methodology that may be applied by a rating agency with regards to the issuance of Sharia compliance and fiduciary rating of such instruments. The objective of this standard is to introduce and set out principle-based guidance on Sharia compliance and fiduciary rating of Sukuk and other Islamic financial instruments, strengthen stakeholders' confidence in the Islamic finance industry and in particular Islamic capital markets, in particular Sukuk and other Islamic financial instruments, improve transparency and demonstrate the compliance of Sukuk and other Islamic finance instruments with the standards, regulations, and best practices to Sharia principles and rules, Sharia governance, adherence to values and fiduciary ratings. It's a very important standard that we have a public hearing on, and your input, feedback, comments, questions, queries, all are welcomed, and we look forward to benefiting from your experience of the Islamic finance industry, and in particular the exposure draft that we have on hand. The exposure draft have already been shared. If you've registered, if you have not still gone through the exposure draft, it will be placed in the comment section or chat window shortly. In case you are unable to provide your feedback and comment today, we encourage you to send it in writing as well on governance@aofi.com. We really look forward to these comments and feedback. This is the second public hearing that we are organizing on this particular standard, and there will be another 2 public hearings at least in English and 1 public hearing in Arabic on this standard. Once all the public hearing session is complete related to this standard, all the comments will be put forward to the particular working group as well as to the AAOIFI Governance and Ethics Board for their consideration, incorporation as they deem appropriate. So we highly encourage you to please share your thoughts through these public hearing sessions. We would like this to be an interactive session rather than just a one-way monologue, which doesn't serve any purpose. So we would like this to be as interactive as possible. We welcome you once again to this public hearing session. Hopefully we will welcome you to the future public hearing sessions as well. I won't say much on this, but would also like to take this opportunity to thank our partners for this public hearing sessions. who have been helping us in sharing the message to the local stakeholders and to a wider audience. Without their support and without spreading the message, our work would not be possible. So we really appreciate the support that comes from our partners, in particular from the Far East region. So we have the honor and pleasure of having our partners with us as well. I would like to take this opportunity to welcome them to the public hearing session, and also invite one of the partner, Dr. Salihin Advisory, to deliver a keynote or a welcome note. It will be delivered by Dr. Hassan Lassasne, the CEO of Salihin Shari'ah Advisory. We will have another welcome note as well by our second partner. So over to you, Dr. Hassan, for your welcome note, please.
Okay, thank you very much, brother Dr. Rizwan. First of all, I would like to express my thanks and appreciation to AAOIFI for giving me this opportunity to say a few words. First of all, this is the second hearing. You just have yesterday one, and this is following a public hearing on Sharia compliance and fiduciary rating of Sukuk and other financial instruments. And this is a very important, basically, initiative that we have seen AAOIFI, mashallah, embarking a few series of public hearing. And this is, in my view, shows the commitment and the serious undertaking by AAOIFI in providing these standards to guide the industry of Islamic finance, remove the ambiguity, create consistency, and guide the entire market. This one, as we are going to hear from the Secretary General on this briefing, I think is a very important, especially from my personal perspective and personal view, is very important standards that guide the industry, especially in the Sukuk space, remove a lot of ambiguity on the functions and the Sharia compliance requirements, parameters, rating scales that's basically undertaken by the rating agency, and how the assessment would be done in the Sukuk and other financial instruments. I don't want to be a stop between you and the standard. I just want to say thank you very much for AAOIFI. I congratulate the AAOIFI for this second public hearing in 2 days, meaning you have a very busy schedule on that. And also, thanks to the other partners who basically contribute to support the AAOIFI for this initiative. And my last message is to basically the participants. Also, my wishes is that the participants who receive these invitations, so it is a part of the responsibility to circulate that invitations to a wider audience and public. So many people will join the public hearing, and the higher and the benefit will be spread throughout the Islamic industry. So we won't keep the invitation to ourselves, but we circulate to our networking. So we have more crowd, more participants, then the benefit will be spread, and the discussions and the deliberations will be more fruitful. With that, thank you very much. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh.
Thank you very much, Dr. Hassan. Thank you for your continuous support to these initiatives, and Far East being one of the most important market for AAOIFI. It is important for us to tap into the local stakeholders and benefit from their expertise, knowledge, and experience. So thank you very much for your continuous support. Inshallah, we look forward to welcoming you again, the future public hearing sessions. So Jazakumullah khair. I would also like to now invite our second partner, Adil Advisory, and to deliver the keynote remarks, and it will be delivered by Mufti Yusuf Sultan, the founder and CEO of the organization. Over to you, Mufti.
Yeah, assalamu alaikum wa rahmatullahi wa barakatuh. Thank you very much, Dr. Rizwan, and also thank you so much to AAOIFI for allowing us to be a collaborative partner for this particular public hearing, and also the one that was held yesterday. It is our pleasure, immense pleasure, to be co-organizing this public hearing event. Related to this standard, I echo what Sheikh Dr. Hassan has also mentioned. This particular governance standard exposure draft is very important looking at the confidence of the industry in terms of Sharia compliance. I think in my personal and also the organizational experience that we have in other advisory and also another entity in Bangladesh, we have seen the public perception towards Sharia compliance is varying a lot. So no matter what the industry size is, the asset size is, etc., but public perception is also very important to make this industry go forward. And one very important aspect that really can take care of when we incorporate such fiduciary ratings that also incorporates the aspects of Sharia compliance and Sharia governance into it. So we have seen AAOIFI had also, there was another standard on overall Sharia compliance and fiduciary ratings for Islamic financial institutions. This one is particular for Sukuk and other such Islamic finance instruments. I hope this will also continue for Islamic fintech, like crowdfunding and others, and the list goes on. So, and also I would echo what Sheikh Hassan has mentioned towards our beloved audience and participants today. Please spread the word, especially those who are AAOIFI fellows. It's a responsibility for all of us to take participation in such public hearings, share our comments and feedback so that those are much more inclusive and ready to implement into the market. Because at the end of the day, we need standards which can be implemented in the market and not only remains as a theory in the standard. With all this, I would like to end my welcoming speech. Dr. Rizwan, of you, Jazakumullah khairan again, and thank you so much. Assalamu alaikum wa rahmatullahi wa barakatuh.
Jazakumullah khair, Mufti Yusuf Sultan. Thank you for your support, and we look forward to welcome you again, inshallah, in the future public hearing sessions. Hopefully our relationship, our partnership and collaboration in the local market enhances through these interactions and with the stakeholders. Jazakumullah khair. Ladies and gentlemen, moving on to the session itself. Just to remind everyone, just to reiterate that this public hearing session is a very important session or very important stage in the standards development process at AAOIFI. It takes us on average about a year and a half, 2 years to develop a standard, and it's a very comprehensive process that AAOIFI has to develop any one particular standard. So this stage is very important where we try and benefit from the feedback of stakeholders, queries of stakeholders from around the world. It's an opportunity for us to present the exposure draft, the document, which is otherwise ready as a standard for market feedback and comments. Once we receive that feedback and comments, they are then incorporated, or they are placed in front of the particular working group, as well as the particular technical board. In this case, it's the AAOIFI Governance and Ethics Board, for their consideration and potential incorporation into the standard. That's what makes the standard comprehensive, because it's not. AAOIFI does not develop a standard just for its own market, rather it develops the standard for the overall global market or the global industry, and that cannot happen without a public consultation and in ensuring that it caters for most of the areas or issues that we have at hand for that subject matter standard related to that standard. So to that effect, I mean, I would not take a lot of time, the standard will be presented by our Secretary General, Mr. Umar Mustafa Ansari. Just to remind everyone, this session is being recorded on YouTube, and it will be made available as we speak, so you can refer to it later on as well. There will be no PPT shared. There will be no PowerPoint presentation of the standard. Rather, the presentation that will be shared with you will be exactly same as the exposure draft document that my colleague has already shared in the chat window. So please feel free to do that. If you wish to have any questions, if you wish to ask any questions, please use the Q&A tab at the bottom of your screen. And avoid using the chat window. We will not be looking at chat window a lot. So question and answer tab to be referred. And if you wish to ask a question by voice, please raise your hand, and we will allow by voice if time permits. Last but not least, this session is being it qualifies for AAOIFI CPD points. So if you are an AAOIFI fellow, please make sure that you record this and share it with AAOIFI at the suitable time. So without any further ado, let me hand it over. I have the pleasure of welcoming the Secretary General of AAOIFI, Mr. Umar Mustafa Ansari, to take us through the standard, inshallah.
أعوذ بالله من الشيطان الرجيم.
We can't hear you, Brother Umar.
Can you hear me now, brother?
Yes.
Okay. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقهوا قولي. Ladies and gentlemen, Assalamu alaikum wa rahmatullahi wa barakatuhu. And indeed, a very good morning and good afternoon, particularly for our brothers from Malaysia and Far East region. And I think that this time a large number of participants are registered from the Far East region. This standard, a very little bit introduction has been provided, I think, by Dr. Rizwan and in the opening remarks by our fellow partners for this event. Thanks to all of them, and thanks to all of you for joining in. I would like to take you a little bit through the background of this standard and a little bit about the project that we are doing right now on this front before taking you through the standard itself. We believe that one of the most important elements for Islamic financial institutions is to have the right reputation. And obviously, having the right reputation requires that you need to be like, how I would better put it, that you need to be more like not only, I'm trying to find the right words. Yeah. It's not only doing the right thing, it's also being perceived as doing the right thing. So it's not only that you do the right thing, but also people should understand and consider that you are doing the right thing. And this is something for which obviously the element of independent sort of certification is important. For sure, we know that the Sharia board's report, and in the countries where Sharia audit is there, that is important. But having a rating with regard to the level of compliance that you have is important. This is just like that, even if you are having a financial audit and the financial statements are available, still you feel a need for having a credit rating. I'll come to the difference between the credit rating and the Sharia compliance and fiduciary rating. First, let me try to address this part of building confidence and having the right reputation. So from the perspective of having the right sort of reputation, we need to consider that there are multiple elements in that. For sure, most important of them is Sharia compliance, but there are additional elements to that as well, and we'll go through those details going forward when I take you through the standard. This is one of the challenges, but there have been other challenges in the market as well. Like, for example, let me put it the other way around. I remember in one of our conferences, it was discussed that most of the, again, it is what I'm saying is without disrespect to any profession or any industry, but there was a comment by some of the speakers about Sukuk that that probably the worst sort of Sharia compliance and non-compliances that happen, they happen because of the lawyers and the credit rating agencies. Now, again, it's not about defaming an industry or a profession. It's more about understanding from where this issue comes. The problem is that that for Islamic finance, there is an unfortunate fact that it works within the legal system and the regulatory system, which is not meant for it. That legal system and the regulatory system is originally meant for conventional financial institutions and conventional financial instruments. So what happens that considering the mindset of the investors, considering the elements relating to like how I would put it, that considering the elements relating to the safeguard of the interest of the stakeholders, and those stakeholders who are primarily concerned because of having the conventional mindset and the conventional practices, they are having the mindset of ascertaining the credit worthiness of the counterparty. So the lawyers, the credit agencies, the way they look at it, they do the things with proper professionalism. And the professionalism that they apply speaks that you need to follow the legal regime, you need to follow the regulatory regime, you need to keep the understanding of the stakeholders in mind, and you need to safeguard the interest of those stakeholders, considering that the credit worthiness of the party and the legal provisions are in a way established through the contract, that there is no or minimum risk of default on the contractual obligations. And obviously, the obligor is the common term which is used. Maybe what I'm talking about is too much philosophical, but the point is that those philosophies were important when we started this project of having the Sharia compliance and fiduciary rating for institutions, and then this second part of the project for Sharia compliance and fiduciary rating for the Sukuk and other Islamic finance instruments. The concept behind having the Sharia compliance and fiduciary rating as compared to the credit rating was that in a conventional instrument and a conventional institution, normally the prime risk that a transaction carries is the credit risk. And whether it is the bank's customers or it is the bank itself or the other financial institution itself, the primary concern of the counterparty is the credit worthiness. And obviously the financial statements are there which talk about the historic performance of the institution. The credit rating actually also takes into consideration the future prospects of the same, which means that I may have very good balance sheet as of today, but how good are my cash flows for the times to come? That may impact my possibility and probability of making payments according to the contractual obligations, as compared to the situation where the balance sheet and cash flows both are good. We can have situations where the balance sheet is good, but the cash flows are not good. Audit may not address some of the aspects which are related to the credit worthiness, although it provides the best understanding of and more reliable. To be honest, the audit provides more reliable information. Same analogy applies in the Sharia audit and Sharia compliance and fiduciary rating part. That yes, Sharia audit is there to talk about the historic performance and the period under audit as to whether the institution or instrument was in compliance with Sharia principles and rules. But the rating also considers the additional elements in addition to the past performance and the current position. It also addresses the probabilities with regard to the future outcome. So I have discussed a lot of philosophical debate on this part. Only one aspect I would like to request you to bear with me additionally, and that is with regard to the fiduciary part. We believe that when a stakeholder deals with an Islamic financial institution, one of the prime considerations is that they want to have Sharia compliant returns, and obviously or returns, or they want to have Sharia compliant transaction. So from that perspective, the element of Sharia compliance is the key. But at the same time, because of the unique business model of Islamic financial institutions and the transaction structures of most of the Islamic finance products, there are additional fiduciary responsibilities. There is one example that I very commonly mention, and that example is like, that if, for example, I ask you that I want to borrow 100 BD from you, and I will give you back it after 1 year with 10% interest. So that is 100 plus 110, 110 BD I'll pay you back after one year. What you will be concerned about, you will see, okay, if this guy Umar has credit worthiness, what is his financial position, and you will see if he has some securities available. You may see that what is my regulatory regime and governance mechanism in which I am working. But from most perspectives, you will see that the primary concern will be whether I have the ability to pay you 110 at the end of 1 year. If I took this money from you and I just went on a trip to Thailand and just spent this money all, you may feel bad about it. You will be a little bit concerned, but would it be the main concern? I would still say that how I use that money, or how I spent or utilized that money or wasted that money might not be the main concern for you. Your main concern in this transaction, which is a conventional interest-bearing transaction, would be that whether or not this guy Umar has still the ability to pay me back 110 BD at the end of the year. This is the conventional side, and this is how the credit rating is done. So in that situation, the credit rating of Umar Mustafa Ansari will be done in a way to see, yes, obviously all the factors of how good he is in using the money and that all, they will be considered as supplementary factors, but they will not be the primary factor. And in some cases, they may not be even considered if I have very good security available to you. So you will say, oh, security is there, so I don't need anything like, to be adjusted for. Now, considering the second option. In the second option, if I come to you and I say, I want to do a Sharia compliant transaction, investment opportunity I bring to you. And in that Sharia compliant investment opportunity, what I do is that I bring sort of an investment proposal where I say that please invest 100 BD with me. I have a very good investment opportunity that I'll be utilizing your money for, and it is expected that after the period of 1 year, according to the profit sharing ratio that I suggest between me and you, you will get inshallah 110 BD. On a lighter note, some people say the main difference is only inshallah. That in this one we say inshallah, and we have a face of a religious scholar for that. But anyway, that was on a lighter note. We are talking about the true sense of Islamic finance here. So the question is, what you will be considering in my case now. If it is not a guaranteed amount, I cannot, under a Sharia compliant contract, I cannot guarantee you. I cannot guarantee you the either the profit or the principal itself. What I can guarantee you is only that, okay, I'll use your money in the best interest for you. So from that perspective, what you will be needing is a bit different. I think what you will be needing is not only my ability to pay back, because it is quite possible that although I may have ability to pay you back, I may be strong enough financially, but I may not be, sorry to say, I may not be like, using your money wisely, which means that while my credit worthiness can be there, but the return on the investment for you goes less than 10%, or even it ends up in a loss situation. Now what happens? According to Sharia, in the Sharia compliant participatory contracts and the contract investment proposal that I took from you, I cannot guarantee the money. I cannot guarantee the principal. I cannot guarantee the return on that, which means that if you start thinking logically, you will start thinking that Umar's credit worthiness is not enough for me. Umar might need to have, have to prove something additional before I am actually convinced to make like a proper proper investment decision for him. This is something that we have a challenge we have it as a challenge on an ongoing basis, because considering the nature of transactions of Islamic financial institutions and the unique business model of the Islamic financial institutions, on a daily basis, you get so many deposits, you have other instruments like Sukuk, etc. But the element of credit worthiness, which is still important. I'm not saying that it is not important, and in some of the products, it is more important. But the element of having the right governance, element of having Sharia compliance, element of being able to manage the investments in the right way, this all becomes important. And this is where the AAOIFI's governance standards actually consider, or in most of our standards, in addition to Sharia governance aspects, we always talk about the fiduciary responsibility related aspects, including the safeguard of the interest of the stakeholders and having the right governance principles in place and having the better asset management and investment management quality. The first project that we did on this, and thanks to our brothers and sisters from International Islamic Rating Agency, they have been partnering with us on this project. The first part of the project was related to Sharia compliance and fiduciary rating for the institutions, and this one, that is Sharia compliant and fiduciary rating for the, actually it is for instruments, but since Sukuk are the most important instruments, so we have named it as Sharia compliance and fiduciary rating for Sukuk and similar instruments. We have worked with them in a way to come up with a rating model that considers not only the credit rating, but also the elements of Sharia compliance and the elements of fiduciary responsibilities. And from that perspective, this we believe this one and the other one, both together, we believe have to play a great role in the development of Islamic finance industry and having a broad-based confidence of the market participants on the Islamic banking side as well as Islamic capital market side. Particularly, this standard to a major extent will be more relevant to the Islamic capital markets, because the Sukuk and some of other instruments that we are talking about are part of the Islamic capital market, even if they are listed or not, but their characteristics are more related to capital markets. Now, I think I have taken too much time on this initial discussion. So let me take you to the standard, but let me ask in between if anybody has a question in it here. Do we have any questions or comments? Normally, we will request everybody to put the questions in the Q&A tab, questions and comments in the QA tab only. But if the time permits, we'll try to allow you speaking by use of voice as well. So now I can't see any question and I can't see any hands raised. So then I'll with your permission, I'll share the screen and we'll take you through the standard. Can you all see the screen?
Yes.
Okay, thank you. So what is written in the preface and in the introduction section, most of it I have already sort of covered. So I would now prefer to take you through the body text of the standard, unless anybody has a comment on my initial remarks, as well as on preface and overview and introduction section. Okay, we have a comment from Brother Muhammad Nadeem. Our credit rating have human resource capability to do Sharia compliance, Sharia and fiduciary rating. Brother Nadeem, welcome. Thanks for joining in. The question is, are credit rating having human resource capability to do? I think you are jumping on a question that is a bit late. So I think you are talking about credit rating agencies. I'm just trying to understand the question. So if your question is about, are credit rating agencies having human resource capability to do Sharia compliance and fiduciary rating? So on a lighter note, you actually missed some of the words, which is not making the question clear to me. So, but I think now I'm able to read your question very clearly. Are credit rating agencies having human resource capability to do Sharia compliance and fiduciary rating? The answer to that is that we have some requirements here in this standard, and we have not performed a market analysis or a assessment of the capability of the credit rating agencies as of now. So I would not be the right person to answer on it based on whether they have the capability or not. I believe that credit rating agencies, the bigger and the good credit rating agencies, actually have very good human resource capabilities. The only thing is whether it is in their priority or not to do this set of service. And if it would be in this their priority to do this set of service, then we have the quality assurance requirements and the minimum capability requirements written in this standard, along with the other standard that is already issued on the Sharia compliance and fiduciary rating. So from that perspective, I would say that while we have not done any assessment, but we believe that developing this capability for them is and should not be a problem. Thank you very much, Brother Nadeem. Okay, so now, coming to the objectives of this standard, the objective of this standard are as follows: introduce and set out principle-based guidance on Sharia compliance and fiduciary ratings of Sukuk and other Islamic finance instruments, strengthen stakeholders' confidence in the Islamic finance industry and the Islamic capital markets, and improve transparency and demonstrate the compliance of Sukuk and other Islamic finance instruments with the standards, regulations, and best practices. Sister Alia, please make a note of it. After regulations, there should not be a comma. Just make sure about the consistency of our writing style, okay? Having a comma is correct, but as a writing style consistency, we need to remove that. To improve transparency and demonstrate the compliance of Sukuk and other Islamic finance instruments with the standards, regulations, and best practices related to Sharia principles and rules, Sharia governance, adherence to values, and fiduciary responsibilities. So in the objective, we are talking about these multiple aspects, and you will see when we go through the details of the standard, you will see how we are addressing that. Scope of that standard. This standard applies to Sharia compliance and fiduciary rating engagements conducted by independent rating agencies to provide various stakeholders on independent, comparable, assessment-based rating it should be the state of. Sister Alia, please make a note of on the state of Sukuk and other Islamic finance instruments, Sharia compliance and adherence to fiduciary responsibilities by the originator. I'll come to this term originator later, and other organs of governance, including where applicable, the trustee and the service agent. The common term which is used is at times which is obligor. The term obligor, which is more commonly used in the credit rating engagements, we have not used it because Sharia compliant contracts and the transaction structures do not always work under a model of creating a direct obligation of the party. Means that the most of these instruments, according to Sharia, may not be liability instruments. Like for example, mudarba. If the sukuk is based on mudarba, it is not technically a liability instrument. Mudarba in contract entitles the underlying the holder of the instrument to have right on the underlying assets. So it is more close to equity instrument, but it may have a maturity or a right of redemption. So because of having these instruments having maturity of rights of redemption, or in other words, a put option, they have similarity to liability also only to that extent. But even the liability may not be guaranteed, the principal or the return thereon. So in that situation, the element of obligation directly might not be there. So in AAOIFI's governance standards, we use the term originator instead of obligor. At times, we have used the term issuer as well, but now we avoid the term issuer also because in some of the instrument structures, the issuer is not the institution or the entity itself. Rather, at times the issuer of the instrument is the SPV. So the responsibility primarily is not on the SPV, rather on the entity which is actually getting the use of the funds generated by Sukuk or the use of the assets underlying that. So from that perspective, we have used the term originator in all of our new standards on a uniform basis. For the purpose of this standard, the assessment shall be performed primarily at the Sukuk and other Islamic financial instruments level. However, considering the nature of the instrument and assessment of the relevant functions of the originator and service provider and trustee may also become necessary in line with the requirements of the standard. So, standard provides the broad guidelines. So considering the structure of the Sukuk instrument, it is quite possible that either of them might need to be used and applied. For example, the originator's board of directors governance practices or the originator's Sharia board governance practices might be relevant in this overall assessment. Similarly, the performance of service provider and the trustee may have relevant elements from the perspective of Sharia compliance as well as more from the perspective of the fiduciary responsibilities. The standard shall be the instrument subject to the standard may include inter alia the following: Sukuk, including those issued by Islamic financial institutions, corporate entities, or governments. Explanation: instruments meeting the definition of Sukuk by whatever name called shall be considered as Sukuk for the purpose of this standard. Investment management instruments, including restricted investment accounts which are not registered as separate legal entities. Unrestricted investment accounts or a class of URIA or a similar instrument. And let me just clarify. What is not registered as separate legal entity does not mean that if it is registered as separate legal entity will not be subject to Sharia compliance and fiduciary rating. The point is it will not be subject to rating as an instrument. It will be subject to rating as an institution. So the other standard that is already issued and finalized on Sharia compliance and fiduciary rating for Islamic financial institutions, that shall apply on that. Sister Alia, if you can make a note of it, because there was some comment on this earlier with regard to some other standards also. So we might need to provide a very short basis of conclusion that why we have excluded the ones which are separate legal entities, because they will be subject to the other standard. Okay?
Yes.
Unrestricted investment accounts or a class of URIA or a class of URIA or a similar instrument, which space is missing here. Sister Alia, please make a note of it. I don't know whether it's in the body text of the standard or in the presentation version only, which are offered as Sharia compliant instruments by an entity other than AAOIFI or by an AAOIFI that is not rated in line with the GS10 as Sharia compliance and fiduciary rating for Islamic financial institution, or an AAOIFI that is rated but considered as having less than targeted rating. Now, this is something that I need to explain. So, for example, there is a Islamic financial institution. That Islamic financial institution, number one, is not first example, is not rated as an institution, but because of market factors or other things, they want to get their URIA accounts or a class of URIA accounts or a similar instrument like URIA account, like certificates of musharaka or Sharia compliant term deposit receipts, etc. So if they want this one to be certified, this can be done as this can be rated, not certified, rated in line with this standard. The second thing is that it can be possible that I have an Islamic financial institution which has a rating of, like, for example, B, in case of its main whole activities of the bank, because some of the activities of the bank may not be ideal. So considering that, the overall rating of the bank might be B. But for example, I'm just putting an example, that institution may have its URIA accounts or a class of URIA accounts that are invested only in high class assets and in line with good Sharia principles and rules. So it is quite possible that this instrument itself may get a better rating than the institution. So, for example, because of the market factors and so many things, for example, there is a bank who has, like, some controversial products, like their credit card does not meet the requirements of AAOIFI Sharia standard, like they are doing too much of tawarruk, which is not preferred by AAOIFI as a preferred product, particularly on the liability side. So if an institution having some of the controversial products and some of the weak governance practices and Sharia compliance practices, it is possible that their overall rating goes down. But still, it is possible for them to get a better rating for one of the instruments or some of the products or some of the instruments. So this is actually, this also happens in case of other institutions as well. Like, for example, when you ask the rating agencies and rating experts, they will tell you that at times, even in the credit rating, it happens that the institution, for example, there is a corporate entity which has a rating of B or double B or triple B, whatever. There are different rating models, but it is quite possible that if they have a bond or a sukuk, it is quite possible if the assets underlying that sukuk are better, or the ring fencing of the instrument is better, or the security provided for the bond is better, and it has the better rights on the security. It is and the instrument itself is more, like, feasible. It is quite possible that the instrument's rating is better than the rating of the institution. So what we are talking about here is not something unique. It is actually a concept that also applies in the credit rating industry. So from that perspective, here we are clarifying that although it is possible that either the institution as a whole is not rated, or is rated but has a less than targeted rating, in that situation, having a instrument rating is still possible. Any other Islamic finance instruments or products offered publicly by AAOIFIs or other instruments as a liability, quasi-equity, or asset product. For example, a Sharia-compliant housing finance product in a country where AAOIFIs do not exist. This is a very good point. Just last few days, one of my ex-colleagues who has moved to a predominantly non-Muslim country, Muslim minority country, he asked me to provide some guidance to him about which of the institutions offering mortgage finance under Islamic modes, housing finance and the Islamic modes, which one is better in that country. Now, Umar Mustafa Ansari, sitting in Bahrain, how he can respond to his colleague who is sitting in a country which is a Muslim minority country far away. Probably I never visited that country. And it's not necessary that all of the institutions there might be in contact with me. So what is the tool that can provide appropriate sort of assessment to my colleague there? Okay, Sharia board is there, all the three, he mentioned two, and then I asked somebody else, he mentioned another one. So now there are three options. There are three Islamic finance houses who provide housing finance. So now there are 3. Now, if you ask me simply, I see big names in one of the Sharia boards. Okay, I say, okay, this one has the bigger names. Is it a good enough assessment just to make sure that these are 3 big names? To be honest, at times we are not even sure that to what extent, because that is not subject to a proper regulatory regime. So we are not even aware to what extent that Sharia board is actually involved in supervision of the affairs of that respective institution, and to what extent they are devoting time for that. And for example, if those scholars are very senior, they might be sitting on multiple boards. So it might be possible that on this particular institution, they might not be able to give enough time, or other way around, this institution might not be involving them enough in day-to-day affairs and supervision of the things. Which means that me sitting in Bahrain, making a comment about these 3 institutions, that which one is better for my colleague, would be absolutely, baseless. Maybe it may not be absolutely baseless, because I checked with 1 or 2 of the colleagues who are into Islamic finance, and they live in the same country, belong to the same country, are involved with the Islamic finance industry. So they have an assessment and they suggested me something. The person suggested me a ranking 1, 2, 3. I suggest these 3, and his suggested one was not from the 2 which were originally suggested by my colleague. Now, what is the solution to this thing? Yes, Sharia audit is one of the solutions. Having a good Sharia governance mechanism is one thing. But when we talk about the Sharia compliance and fiduciary rating, it actually takes into account all of these things. And the difference between the audit and rating, with this we need to understand here. The audit gives you either a clean report or a qualified report, and again, obviously there can be disclaimer or adverse report. But normally, for the minimum level of compliance on a materiality basis, you will get all of them a compliant report, which means that the compliance at the minimum level is there, so there is a Sharia audit report. But what about the level of compliance at 2, 3, 4 different levels? For example, I just gave you an example. The AAOIFI Sharia standard says that tawarruk should be used only on need basis. And there are some of the institutions who use 90% of their balance sheet, both on asset and liability side, on tawarruk. AAOIFI Sharia standard does not prefer to have using the tawarruk or commodity murabha or reverse murabha as a means for getting liquidity, for raising deposits, etc. But it happens in some parts of the countries. So the question is, if I move from Pakistan to Bahrain, how I get this information that among the 5, 6 full-fledged banks and some of the windows that are available, which one is having a closer compliance level to AAOIFI standards? Not only AAOIFI standards, forget about AAOIFI standards. The AAOIFI standards are just a criteria to determine Sharia compliance. You can apply any other criteria as well if you like. But the point is that issue, that challenge still remains there. So from that perspective, we consider that different type of products can be covered, including asset side products within the same criteria. So this standard provides the overall guidance that even the same criteria can be applied on asset side products as well, particularly like, for example, the housing finance or car finance products in countries where IFIs do not exist, or if IFIs are there but a regulatory regime is not there, etc. I think I can see a comment in the Q&A tab. Brother Sadaqat Khan, Assalamu alaikum and welcome, sir. Thank you very much for joining in. The instrument subject to the standard may include this. Your point is conventional financial institution can issue Sukuk or not allowed. An excellent comment, sir. Excellent comment. The point is that the purpose of this standard is not not to allow or disallow Sukuk by conventional institutions. Sukuk has an understanding that the underlying assets and the use of money should be for Sharia compliant purposes. So AOIFI has a stance. AOIFI's stance is, if you see that AOIFI has a Windows standard on the accounting side, which also addresses this issue. We have issued exposure draft on Sharia governance framework with joint with IFSB as well. So considering those things, what we have written already in final standards or exposure draft, and considering some of the requirements of Sharia standard, which might not be very clear, but they give us guidance with regard to the legitimacy of the underlying assets and the use of the proceeds of the Sukuk. Considering that, we can say that conventional financial institutions can issue Sukuk only out of their Islamic finance windows. And Islamic finance window within the definition of AOIFI standards becomes an Islamic financial institution in itself. So AOIFI's stance is that conventional institutions cannot issue Sukuk, conventional financial institutions, because their primary business is not considered to be Sharia compliant predominantly. They may have some Sharia compliant services and they may have some Sharia compliant activities, but their predominant business is not considered to be Sharia compliant and cannot always be assured to be Sharia compliant. So from that perspective, we have these requirements. We have our governance standard on Sharia compliance and fiduciary rating, also on Sukuk governance GS12 also, which actually addresses a lot of challenges which are there with regard to this thing. So Sharia standard, governance standard on Sukuk, and accounting standard on window. When you try to read them all together, and I can tell you that even the Sukuk Sharia standard of AOIFI, because it talks about the use of the funds and the underlying assets to be Sharia compliant. Considering all these things, in a nutshell, AOIFI's stance is that generally conventional financial institutions cannot issue Sukuk unless they do it through their Islamic finance windows or using the Sharia compliant modes and underlying assets and proceeds for Sharia compliant purposes. And for that purpose, a window of conventional institution is also considered to be an Islamic financial institution. So your question was, sir, very, very complicated. I have tried to answer. But to be honest, I will not prefer to go in this debate further for this standard today, because this standard subject is a bit different. But I tried to answer you based on the stance AOIFI has taken in different standards at different places. Thank you again very much for this very important comment. Coming to the next section, responsibility. Now I'll go for, I will not read out everything with regard to this standard. Some of the elements of this standard are, quite long, so maybe it will not be possible for us to read through the standard word by word, but we'll try to cover most of the requirements here. In a nutshell, what we are saying, that is standard, this standard applies to the rating agencies. Whatever the contents of this standard are for the rating agencies. So the responsibility of application and requirements of this goes to the rating agency. Who are the rating agencies? And I can recall whether Nadeem had a comment earlier, so we'll have an answer to that going forward. Now, what we are saying here in para 6 is important. What we are saying that it is highly recommended that all Sukuk and other publicly offered Islamic finance instruments, excluding those offered by IFIs which are rated already under GS10, those shall be subject to a Sharia compliance and fiduciary rating. So it is highly recommended that every Sukuk, every publicly offered Islamic finance instrument, they all shall be always subject to a rating for this. Again, what we are recommending today, we are far from that. It will take time, but the world is changing. Now people want green Sukuk. We are having green Sukuk rating and other type of ratings for climate related and all that. Rating and assurance, both are coming up. The question is why the Sharia compliance part and the fiduciary part is not being given that much significance. The reason is, sorry to say, the problem lies in the concept that as of now, Sukuk are considered to be just a bond. People think that they are just making a bunch of papers to make it compliant. Otherwise, they don't need to change anything on the back end. They don't need to change the financial reporting. They don't need to change the governance system. They don't need to do any additional activities. They don't need to, like, to fulfill any additional requirements. What they think of is, again, I'm talking about a predominant factor. And again, I would refer to the institutions with the conventional mindset. I would refer to the sovereign sukuk. I would refer to the approach taken by the credit rating agencies. I would refer to the approach normally taken by the lawyers. That the approach that is there right now today is, people think the bond it is just an Islamic bond. That's it. The question is, I have personal investments in some sukuk. Sukuk issuer or the originator is not providing me any information as of now with regard to the Sharia compliance of the proceeds. It's not providing me any information as of now with regard to the financial reporting of the underlying assets, that how the underlying assets are performing. It's not giving me any update on that. Yeah, I'm a bit conscious about these things. So at least when I do an investment in a sukuk, at least I try to check, okay, what I'm buying, what is the back-end asset. So at least I try to get some back-end asset related information. And in case of Ijara sukuk, obviously I can say that, okay, something is easier. But if you ask me, Umar, can you go and invest in a corporate sukuk now? My question is, I may consider it very difficult for me as an investment decision maker to go and invest in a corporate sukuk because I do not have all this information available. AAOIFI has done a very comprehensive project in last 8 years. It's a long project actually. And maybe it is going by before the end, it's going to take 1 or 2 more years, in which we have worked on sukuk as a comprehensive project. So some of you might already be aware that on the accounting side, we issued 2 standards already, one on the investors accounting for sukuk, FAS 33, one on the financial reporting for sukuk holder. That sukuk holder must have the minimum financial information, that is FAS 34. Then we have issued FAS 29 exposure draft, and we have recently issued again the exposure draft of FAS 29, which addresses the financial reporting in the books of the originator. And that is why I'm mentioning that, because it has some correlation here as well. Because FAS 29, which is still not final, but it defines that what sukuk can be a quasi-equity sukuk, what can be a equity sukuk, what can be a liability sukuk, financial liability sukuk, and non-financial liability sukuk, and what would be an off-balance sheet sukuk. So these are some of the guidance which are available in our accounting side already. As I mentioned, GS12 on the sukuk governance has already been issued by us. Now, as of now, we are in the process of final editing. It is reviewed and approved by the Sharia board, but final editing is being done for a very comprehensive sukuk Sharia standard, very comprehensive. So we believe that a lot of these activities were needed at the end of AAOIFI, but this actually is, I would say, icing on the cake. That once you have all the standards in place, you need to have a rating to assure you and to give you a comparative assessment of how the different sukuk are complying with the requirements of these standards, and to what extent they have fulfilled the Sharia, and are expected to fulfill the Sharia compliance and fiduciary responsibilities. Brother Nadeem has a good comment, but I would take it a bit later, because the question that he has raised is a very good, but it is related to a stage where we will reach in a bit. Brother Sadaqat Khan has a comment about rating agency, so I'm just coming to that. So I'll take that comment also. Thank you very much, both of you. Allow me just a few minutes to take your comment. Okay. Okay, so let's move ahead with the responsibility part. Now we come to definitions. Islamic financial institution definition is standard as per AAOIFI. As I mentioned, it includes Islamic windows and standalone branches, etc. Instrument is as defined in para 4. We'll go to that. Originator I mentioned already, which may include an institution, which is Islamic financial institution. It may include a corporate entity or a government also. But our point is that even if a government entity or a corporate entity or a semi-government entity that originate a sukuk or issue a sukuk in line with Sharia principles and rules, directly or through another SPV mechanism or other similar mechanism, in all this situation, the originator is the original party, which has to fulfill the requirements of originator here. Rating agencies, for the purpose of the standard, is a company or a firm that assigns Sharia compliance and fiduciary ratings. See paragraph 8 and 9. We'll go to that in line with the requirements of the standard. Brother Sadaqat Khan has his comment here. His question is, rating agency shall be certified and approved by AAOIFI, or any rating agency can perform the task. I'll come to that, sir. I have the answer to that it has to be approved by the regulator. AAOIFI is not a regulator. AAOIFI is a standard setter. So we normally do not go for any certification or anything like this. We are actually the standard setter. So we are actually leaving it to the regulator. I'll come to that point in paragraph 8 and 9. Thank you very much again, sir. Rating scale. Now we need to understand that. Now partially I'll answer brother Nadeem's comment here. Brother Nadeem's comment is, will the rating address the instruments like halal, haram, fasid, makruh? So actually, our first thing is, we are not talking about anything that gets a reasonable rating has to be within the halal limits. So if it is not in the halal limits, it will not get a rating, or it will get a failed rating. So that is the first point. So either it will not get a rating or it will get only a failed rating. So that is the first thing that we need to keep in mind. Second thing is, yes, we are clarifying, but we are clarifying on the basis of rating scale. So let me try to explain you that rating scale, how it works, but we need to understand that the rating scale also works for not only for the Sharia part, but also for the fiduciary rating part. Now the difference is that assurance, certification, audit, review, they all come up with the answer yes or no. They don't come up with a comparable answer. So for example, review and audit are types of assurance, even if they are Sharia compliance review and Sharia compliance audits. So they are part of a type of assurance. Review normally has a moderate level of assurance, and that low level of assurance normally is expressed in way of a negative assurance. So the expression of opinion is something like, we didn't find anything wrong. On the other hand, the audit comes with a reasonable assurance, which is above the moderate assurance provided by review. And audit comes up with an answer that materially all is correct, or materially whatever is the subject matter, it is meeting the criteria. So criteria is the Sharia compliance, and the subject matter is the entity's compliance or the instrument's compliance, and it meets. So I will give a positive opinion that materially, in all material respects, because absolute assurance cannot be there. Reasonable assurance is also not an absolute assurance. Now, rating works in a different direction. Rating starts with the presumption that everything is okay, but something is good, something is average, something is bad. So rating scale is the range of potential outcomes from which one would be assigned to an instrument at the final summarized output in the form of an alphanumeric or any other symbol. So you can have AAA, AA, A+, B-, this sort of numbering, or less commonly as a numeric score. So you can have a numeric score also, that it gets 70 out of 100 or 85 out of 100. So it can have a numeric score or a alphanumeric. So it's both options are available, and which would form a part of hierarchical representation reflecting the relative rank of the instrument. So we are talking about the relative rank. We are not talking about, so if everybody has passed, but some of them got first position, some got second position, some got third position, and somebody was in the D grade. So this is the relative and comparable sort of ranking, which actually gives you the relative rank of the instrument vis-a-vis the benchmark parameter. So again, you need to, how you give that ranking. Oh, I like this one and I don't like this one, and this guy is beautiful and this girl is not beautiful. No, it has to be according to a benchmark parameter set. And this standard, one of the major scope of this standard is about establishing the benchmark parameter set. We have another comment from Brother Shoaib Chima. Please explain current status and progress of Islamic Rating Agency and major hurdle to adopt it as AAOIFI at AAOIFI's level. Can I ask if anybody from IRA is represented here today? Anybody from IRA is represented here today? Sister Alia and brother Rizwan, if you can kindly check. If somebody from IRA is represented here, I would love that if they can speak for 2-3 minutes on mentioning what they have done till now on that, because IRA as of now, International Islamic Rating Agency, which is one of the Islamic finance infrastructure bodies and is part of our project, partner of our this project, this one plus the institutions rating project, they actually have done some good job in this area. As of now, I believe some time back, I believe they had more than 45, 46, I think ratings on the institution side, and I think they have some instrument side rating also started. They've started working on that also. But this standard is not yet final, so we can't say that any rating is done in line with this standard, but they have done Sharia compliance and fiduciary rating without applying AAOIFI standards and with applying AAOIFI standards as well. So we'll see if our team can coordinate, if somebody from them is there, or if there is anybody representing them, if they can just raise the hand, we will give them an opportunity to speak. So Brother Shoaib Chima, the quick answer is that on the institution side, yes, the progress is there, but that progress is nowhere close to what should be there by now. And with regard to instruments, it is a comparatively newer idea. We believe that they were planning to work on and they were trying to do it for 1 or 2 products already. We might learn it better from them. Anybody interested in this service? Again, it's not a marketing exercise, but since we know as of now that IRA, and obviously IRA is one of the international Islamic infrastructure bodies established under the ambit of Islamic Development Bank, under the patronage of Islamic Development Bank. So they are already doing this service. And if we come to know, and we invite all other credit rating agencies to start this service, and any one of them who is interested and who let us know about this activity that they have started in line with the AAOIFI standard, will be happy to mention that in our events. So as of now, we are aware about only IRA, so I'm mentioning only IRA. Not as a, again, I don't feel any harm in marketing a good thing. So if there are more than one service providers, we'll market all of them. Not a problem for that. So anybody interested can approach them. Thank you very much, brother. Okay, now brother Nadeem's question about the rating scale. So I'll try to take you through, I'll jump you through something towards the end of this standard, where I'll show you how the rating scale would be, and we'll come back to some other details later. But let me mention about this thing, if you allow me. It's taking a bit time, so let me do it faster. Okay, I'm just giving you an idea because of in the public hearing we cannot go word by word. But brother Nadeem, the answer to your question is how rating scale would work. So following is a suggested scale. Again, no, it is not. First thing is, a rating agency shall determine and publicize a rating scale based on the determination of benchmark parameters and relevant weight of components of the same. I'll come to the weighting parts later. A rating scale is suggested to have a span of 5 to 10 step grades and entail an explanation of expectation of state of affairs with regard to Sharia compliance and adherence to fiduciary responsibilities associated with such grade respectively. So rating agency will do it by themselves. This is only illustrative. But this is just to give an idea how it will work actually. So AOFI on this standard do not insist that you follow only this scale, but we believe it's a good scale to work with. So it is given as an illustration. So you can have score ranges 90 plus, and you can have like, you know, the alphanumeric system or alphanumeric system. I think in this one, some symbolic or alphanumeric numbers are missing from this column. Sister Alia?
Yes, brother.
I can see that ratings scale and the first column had some alphanumeric numbers just as an example. Those are missing in the table right now. You just make a note of it, please, because in the other standard we have kept them. So I don't know why it is deleted here. Okay. Just make a note of it, please.
Yes.
So anyway, this is just like sort of suggested. Can you still see my screen?
Yes, brother, but it's not good.
Okay, so for example, we say rating in this 90% plus rating is AA or AAA, alphanumeric numbers can be there. And then we say it is 90% plus, so score range is 90% plus. It's excellent level of compliance. Underlying structure of the instrument is preferred in terms of Sharia principle and where it's free of any controversial elements. To extent relevant to instrument and excellent governance commitment environment is maintained. Fiduciary performance is expected to be excellent. Okay, then we have between the second scale, which can be, so first one, for example, was AA, and this one can be single A. And again, you can have like, you know, a good level of compliance, good level, very good level of compliance, good level of compliance. So we started with excellent, very good, good, high satisfactory, highly satisfactory, reasonable, and then unsatisfactory. So if you get less than this, again, these are the ranges which are just a suggested range. There is no insistence on these rates by these scoring ranges by us. Every institution who is doing the rating according to their own methodology can come up with a mechanism, and they can go by the scoring system, and they can go by the scoring system, as well as they can go by like, you know, scoring system or the alphanumeric system, numbering system or the alphanumeric system. Okay. So rating scale, I prefer to discuss that part with the definition. Then we have rating engagement, which it is an exercise of rating engagement, and the Sharia compliance and fiduciary rating is the engagement in line with the requirement of paragraph 11. Sharia principles and rules, we have a hierarchy of Sharia principles and rules which is defined in all of your fee standards. So I do not want to like, you know, address this challenge again. There are some elements related to that which are relevant, because so we may touch upon them when we discuss about the about some of the jurisdiction specific things. Now, what is the eligibility to conduct ratings? This is the answer to the question from Brother Sadaqat Khan, that a credit rating agency duly licensed or recognized to function as such by respective regulator, having developed the capacity and methodology in line with the requirements of this standard. AOIFI is the standard setting body, not a regulatory body. So AOIFI cannot take that responsibility of assessing the capability of the respective rating agencies, and this is something to be done by the regulator. But we gave two options. We said one option is credit rating agencies can start doing this function by adding the capacity to them. And this partially answers to the question by Brother Nadeem in the initial phase of the discussion, that they may not, they have or they do not have is right now not our capacity to determine, but the standard requires that they must have. The second option is that there can be specific Sharia compliance and fiduciary rating agencies, and those are to be licensed in line with this, and obviously they need to have capacity and according to the requirements of GS10. Eligibility to conduct ratings. So either of them, whether a credit rating agency getting the license of doing fiduciary Sharia compliance and fiduciary rating, or or specialized Shari'ah compliance and fiduciary rating agencies, both have to apply requirements of this one, because going forward they will all be called rating agencies. So they need to meet the ethical requirements. They need to meet the requirements of quality control. Quality control requirements are already in GS10, so we did not repeat them. Which follows the requirements of GS10 with regard to the acceptance of rating engagement, because there are some requirements about their own capacity building, quality control and capacity building, and the others are related to engagement acceptance. And then they need to have the fit and proper criteria, which also includes the capacity building part, which is also given in GS10. So instead of whatever is given in GS10, repeating it here, we have created cross-reference to that. That standard part is already finalized, so we do not need to repeat that. Again, comments you can provide on that area as well after reading that. Ethical requirements, you need to follow the AAOIFI Code of Ethics for Islamic finance professionals. Then any other code of ethics which are applied by the regulator or applied by your own code, practices, you need to apply that. In addition to AAOIFI Code of Ethics and not in contradiction with AAOIFI Code of Ethics. Now, next part is the most important part is assessment scope and benchmark parameters. So the benchmark parameters are from two aspects. One is the Sharia compliance and governance part. So from the Sharia compliance and governance part, the first element is compliance with Sharia principles and rules. If you allow me, I'll take you to a table. That table will actually explain you this thing better. So instead of going through all this wording, I'll try to explain it by explaining in the table. Okay, maybe this is a bit small for you to read, but this is available in the standard, and the standard is always all available to you, so you guys can have a look at it. So, for example, what are the parameters? On the left side, we have the benchmark parameters components. Again, parameters are to be defined in detail, but these are the main parameters. So compliance with Sharia principles and rules is the first and the most important parameter. In terms of compliance with Sharia principles and rules, we have defined that Sharia principles and rules are to be determined according to the hierarchy I have mentioned. In some of the situations, it is possible that that country does not adopt AAOIFI Sharia standards, which are the first part of the parameter. In that situation, if you want to give a AAOIFI compliant rating, in that situation, you need to still apply the AAOIFI's criteria and AAOIFI Sharia standard. But if it is happening in that country that some of the AAOIFI standards are not applied, and there is a contradiction, in that situation, you can mention that a different set of Sharia principles and rules, other than the one that is defined in this standard, that rule which is applicable in the specific jurisdiction, that one is applicable. And in that situation, you will say that this is a jurisdiction specific rating, not a generalized rating in line with this standard and in line with AAOIFI standards. So compliance with Sharia principles and rules is first and the foremost, and it is given, like, if you can see it in all the options, it is given between 30 to 35% of the criteria. Okay. Now the second parameter is the Sharia compliance. Let me explain quickly. Sharia compliance principles and rules which are determined and which the institution is complying with, they cannot always be implemented in a proper way unless you have a good system of Sharia governance. So the Sharia governance framework, which also addresses the Sharia aspects and some of the fiduciary aspects as by AAOIFI, and also considering some of the aspects which are covered by IFSB. So that Sharia governance framework, considering the originator, instrument, and service provider and trustee, this all is to be considered as the second main component of the benchmark parameters. So you need to see to what extent the originator and the instrument and the Sharia, and like for instrument, you need to see the compliance with GS12, that is the Sukuk governance standard. For originator, you need to see compliance with multiple AAOIFI standards on the governance side. And for trustee and service provider, you need to see anything which is relevant to them in some of the situations. I'll come to that in what situations it becomes more relevant. Corporate governance practices is the third area, because corporate governance practices, actually good corporate governance practices, ensure the fiduciary responsibilities. And particularly, we are talking about the corporate governance practices which are more related to Sharia governance and Sharia compliance and implementation. So for example, For example, the board of directors' responsibilities with regard to Sharia compliance, the audit committee's functions which are related to Sharia compliance in line with some of the AOFI standards. So some of the additional aspects which are there in the AOFI and IFSP standards with regard to the corporate governance practices, those are to be covered here. The third part is with regard to the transparency and disclosure. That because transparency and disclosure is the key of having having reliance on the system and on the instrument. So from that perspective, it is very important that transparency and disclosure requirements are fulfilled. For that, you need to see the financial accounting disclosures as well as other disclosures, corporate disclosures, for example, in line with IFSB standard number 19 and AOFI's relevant standards, for example, AOFI standard FAS 34, etc. Then ethics and values. You need to see to what extent this institution follows the ethics and values in line with, particularly if it's an Islamic financial institution, or even in case of Sukuk, you need to follow the ethical requirements which are given in AOFI's standards and other ethical codes which are applicable. This becomes part one together, which is the main Sharia compliance and governance part. The second part is the fiduciary performance and capacity part. Although the Sharia compliance and governance element also include the fiduciary responsibility related governance elements. But then there are still additional elements of fiduciary performance and capacity to deliver. So those elements include the asset quality and returns and credit worthiness of the originator. These may be more of the quantitative nature. So the first points, the item number 1, are mostly on the qualitative nature, but the items related to 2 might be more of the quantitative nature, numeric nature. Now, these are the benchmark parameters, but the question is whether these benchmark parameters apply to all type of Islamic finance instruments in the same way or differently. So we have classified the instruments in 4 different types: equity and quasi-equity without purchase undertaking, quasi-equity with purchase undertaking or guarantee, liability, and asset. So there are 4 categories, broad categories. Again, the advantage that has been provided in this standard is illustrative. It may be different according to rating agency to rating agency, because they have to determine their own benchmarks, and considering different situations, they can come up with a slightly different model. But this is something which we have provided as a overall sort of suggested benchmark. Now the point is that these elements of benchmark parameters that I identified, they may be applied to different instruments in a different way. For example, they may be applied to equity instruments. Like if, for example, there is the tier 1 Sukuk, which is based on Mudarba and which is convertible into ordinary shares and does not have a put option. Or there is a quasi-equity Sukuk, which has a put option eventually, but may not have a purchase undertaking or guarantee. So it means that it has to be redeemed at fair value basis. These instruments become, in their nature, very close to equity instruments, and for accounting and regulatory purposes, equity instruments will be defined as equity, and these other quasi-equity may also, some of them, be classified as equity as well. I'm not going in that detail. That's an accounting and regulatory issue, not an issue of rating right now. These instruments, if we see, Sharia compliance is very important. So at least 30 to 35%, from 30 to 35%, there should be always at least 30 to 35% of weightage assigned to the Sharia compliance part. How you determine Sharia compliance part? Obviously, you have to do a quick review, and then you have to see the reports of the Sharia audit, internal Sharia audit, Sharia board, Sharia compliance. So you need to see the reports and the state of compliance that comes from that. And maybe you might need to, as a rating agency, you might need to have a look at some of the things just to have a clear idea about this thing. Then it comes to Sharia governance framework. So if you see here, the involvement of originator, instrument, and service provider all is very important. So even the weightage which is applicable to Sharia governance framework is distributed into originator, instrument, and service provider. This applies to these instruments, not to other instruments. Why? We can go in those details, but right now let me try to explain in a brief first. The second part is related to corporate governance practices, for which, if you see, we have given between 10 to 15%. Only in liability instrument, the weightage for this might be less, and even for the Sharia governance framework. For liability, for example, we'll come to that, but a hybrid instrument shall be considered as a liability instrument if its substantial portion of its returns is originating through the liability component of the instrument. So we have given some guidance on this part with regard to how a liability instrument is determined. So some of the hybrid instruments, which include tawarruk and wakala, or tawarruk and mudarba, whereby the major return is coming from the liability component, that is the tawarruk component. This is the common form of hybrid instruments in the Saudi and the UAE market and some other markets. So these instruments will be may be considered as liability. And in that situation, the governance of the corporate governance and Sharia governance requirements become comparatively smaller. And in that situation, if you see 2B, it becomes bigger. It goes up to 35 to 45% because the credit worthiness becomes so important in that, and governance becomes less important because these instruments have more characteristics closer to the conventional bonds. And I'm not challenging their legitimacy, but we know that a lot of them are not compliant as per AAOIFI's Belden standard and AAOIFI's current standards with regard to Sukuk, etc. So we know that these are having challenges. They may not be compliant with AAOIFI's even FAS 30 standard. So considering all these things, I would say that the weightage to be assigned to different components of benchmark parameters would change according to the nature of the instrument. And this is an example as to how a liability type instrument where the major component is liability, or it's a salam sukuk, which is mainly a non-monetary liability sukuk. In that situation, the element of credit worthiness becomes bigger. Fiduciary asset quality and returns become not applicable, and the element of governance and Sharia governance, etc., go down. Sharia compliance has to be there for sure. Sharia compliance is still an important element. There is another argument that a good scoring system, having mentioned each of the benchmark parameters separately, would be a better approach towards rating, rather than having a one simplified rating on an alphanumeric basis, or at least based on 2. This is an argument. So we kept these options open in the hand of the rating agencies as to how they feel this will better work in the market. This table provides you situation. I will just distinguish the quasi-equity with purchase undertaking and guarantee from the quasi-equity without purchase undertaking and guarantee. What the difference does it make? So for example, if it is a mudarba sukuk, but there is an expected redemption value, which means that there is a purchase undertaking or a guarantee. Again, I'm not challenging the Sharia point here because there are some Sharia compliant solutions to these issues as well. So in that situation, if that element is there, then the credit worthiness element comes in. While in the first option, where there is no purchase undertaking or guarantee, the credit worthiness element does not kick in. So these are some of the examples as to how the system works differently for assessing different type of instruments. I hope that, again, I know that we may not have enough time to address all of these challenges. Brother Sadaqat Khan has a comment. Brother, you are speaking very fast. Kindly keep the pace little slower at the time is allowing. Sir, I think time may not allow it completely, but thank you very much for mentioning. Maybe people say to me, you speak a lot, and at times when there's so many things come up, I may speak a bit faster. So my apologies if I have not been clear about anything. So I'll request you and all of the participants today, if anybody feels anything was not clear because of me speaking very fast, please feel free to ask me to repeat that part or to clarify that part further. Thank you very much, sir, for your kind suggestion. Now I'll go back to the place where we left, and actually again we'll not go to each of the paragraphs. We'll not read each of the paragraphs one by one. We'll just go through the main requirements. So we discussed the six categories of part A and part B. Then we come to Sister Alia, can you just make a note of it? I just noted that in the table we have 1 and then A, B, C, D. Here we have A and then Roman 1, 2, 3, 4. You got my point?
Yes, brother.
Yeah. So we need to align what is in the table with this one. So it will become A, then Roman 1, 2, 3, 4, 5, and then B 1, 2, 3, 1, 2. Okay.
Yes.
As I mentioned, I'll not go through all the details of because it's a long standard, so I'll not go through all the details. I tried to explain you 4 types of instruments. I think asset type instrument I also gave example earlier when we were discussing the scope of the standard. So from that perspective, we'll try to cover some more discussion going forward as the time may permit and as the questions come in. On the equity type instrument, etc., I'll just give you examples. So first thing is the criteria. Criteria of equity type instrument is that the instrument represents a residual interest in the underlying asset. The instrument is perpetual and or convertible in nature. The originator of Sukuk instrument has an unconditional right to avoid delivering cash or any other asset to the Sukuk investment holders by converting it or by saying that we want it to be perpetual, and so the put option is not there, so it does not meet the criteria of liability anyway. And the instrument shall be subordinate to all liability and quasi-equity instruments of the entity, excluding those only the share capital and or other similar instruments. So this is the criteria for equity instrument. Then coming to quasi-equity instruments are those instruments which have characteristics of both equity and liability. Primarily, these entail sharing of profits and losses as applicable and having a claim on net underlying assets. However, they are classified differently from the equity type instrument because they have a put option in the hand of the holder. That is, they are redeemable on a due date or on demand. Hence, they also have a liability characteristics. Any quasi-equity type instrument that does not entail a guarantee or capital through any form of guarantee or purchase and taking shall be kept in this category along with equity type instruments. So we have the first category, including equity instruments and quasi-equity without guarantee or purchase undertaking. Sister Zara, so Sister Alia, please again, consistency, because in other places we are saying without guarantee or purchase undertaking, and in the heading we are saying only without guarantee. Okay. Just need to make sure consistency here. You got my point? In the heading, it is appearing only without guarantee.
Yes, sir.
Okay. The risk and return characteristic of such instruments are representative of the performance of the underlying assets. So that's why we have kept like more of the asset management quality and the fiduciary performance and more on the Shari'ah governance and corporate governance elements and less on the creditworthiness part. Rather, creditworthiness part we kept 0. Because since there is no purchase undertaking, so there is no purchase guarantee or purchase undertaking, so there is no credit element in that. Even if they have a maturity date, still the credit element is not there. So these may include a different type of share capital like Shari'ah compliant preference shares or tier 1 Sukuk, which can be on with different models, and Sukuk and restricted investment accounts that are eligible for off-balance sheet accounting. So if Sukuk are subject to off-balance sheet accounting, then they may mostly come in this one, particularly if they don't have the guarantee element or the purchase undertaking element. I'm not going through all the details. So now coming to quasi-equity type with guarantee or purchase undertaking elements. These instruments include quasi-equity type Sukuk or other instruments where a guarantee or purchase undertaking provides a guaranteed amount of redemption or maturity. So it can be guaranteed or promised. Sister, please make a note of it, because purchase undertaking does not mean guarantee. Purchase undertaking means a promised, a guaranteed or promised amount of redemption or maturity. Okay, so in a nutshell, what we are saying that these are having primary equity characteristics. Primarily, they are subject to the same risks about the assets. But because of having a purchase undertaking or a guarantee, the credit element kicks in. So we have given some weightage to the credit element in that as well. And most of the Sukuk, we believe most of the Sukuk will fall in this category, other than hybrid Sukuk. There are hybrid Sukuk. If you see 20C is referring to that some of the hybrid Sukuk as per 14 or paragraph 21. If they are subject to 14, they become equity instrument, and if they are subject to paragraph 21, they become a liability instrument. Now, liability type instrument refer to Sukuk or other instruments which are based on transaction which result in the creation of a monetary or non-monetary liability for the originator, such as Murabaha, commodity Murabaha, Tawarruk, Salam, and Istasna. These instruments include any hybrid Sukuk whereby, subject to the fulfillment of Sharia principles and rules, including the tangibility ratio, a combination of liability products is used with the participatory product. Sir, any such instrument, Sister Alia, please make a note of it. This combination of liability product, this S should be in brackets, so it can be a singular product or multiple products. Okay.
Yes.
Any such instrument shall be classified as liability type instrument if ratio of its liability component at par value, that is the sale price of the transaction, including the cost and profit, mostly or at times during the continuity of the instrument, is more than 50% of the underlying asset, duly considering the tangibility ratio in line with Sharia principles and rules. And the return from its liability component the return from its liability component provides more than 66.67% of return of overall instrument. So what we believe is a Sukuk based on Salam, a Sukuk based on Istasna, a Sukuk based hybrid Sukuk. Most of the hybrid Sukuks which have Tawarruk, they will be actually subject to this liability type instrument classification. Asset type instruments, any asset type instrument, as I mentioned, I gave example of housing finance, but there can be other examples like that. So these are the instruments that will be subject to this one, and these can be these can be done according to, like, an institution, an Islamic financial institution may be having a B rating, but their housing finance may be fully Sharia compliant, so they would like to have a AAA rating for the housing finance product, so they can do that. Or in the countries where Islamic finance is not available on a very proper regulated basis, or not too much information is available to the users. In that situation, based on the example that I mentioned in the beginning, we can have like asset rating for an instrument, and this can be done by a financial institution, and this can be done even by a non-financial institution. So at times, there are non-financial institutions who provide leasing. Those leasing can be Sharia compliant. So in those situations, this can be there. So again, there can be different approaches towards that. There are installment sale businesses. There are fintech products. I think that the fintech products on the asset side might be subject to this rating going forward as well. Now, establishing the benchmark parameters. For each of the areas we have talked about that how the benchmark parameters will be determined. Okay, so for each of the area we have identified that again, first thing, as I mentioned, that the rating agencies are authorized that they can be following the procedures that that they want to adopt. So the benchmark parameters and the methodology, all these things within the parameters of this standard can be independently set up by the respective rating agency. But again, here we have suggested that what are the approaches towards the determining the benchmark parameters in line with this standard. So the benchmark, you cannot say, oh, we develop benchmark parameters according to this standard and we completely ignore the benchmark parameters criteria given by AAOIFI in this standard. So for example, the Sharia standards issued by AAOIFI or the Sharia aspects of the financial accounting standards issued by AAOIFI, I'm just completely ignoring it. If you ignore it, you can still do a Sharia compliance and fiduciary rating, but that will not be according to AAOIFI standard. It will be according to AAOIFI standard, but it will not be a AAOIFI compliant rating. It will be a jurisdiction specific rating. So these are the criteria for Sharia compliance. Then we have the criteria for Sharia governance framework, which include the standards issued by AAOIFI. The first one probably will be the jointly one issued by AAOIFI and IFSB, and the other ones will be by AOIFI, particularly the Sukuk standard, and then Sharia governance standards by IFSB and the respective jurisdictions standard. Similarly, then we will have, again, there are some explanations to this part, and some of the things will be relevant to the originator, some of the things will be relevant to the trustee and the service agent, etc. as well. So all these things we have identified here, that these are to be done according to the respective rating agencies' approach, assigning some of the weightages and applying what criteria is there is up to them. Only thing is that if they do not fully comply with the requirements of the standard, then they cannot call it that it is a AOIFI compliant, fully compliant rating. They need to say that's the jurisdiction specific rating or their specific rating. Some of the explanations are available here in this section, which actually I explained very briefly when I was explaining you the table as well. Then we have the corporate governance practices. So we need to see the IFSB, AOIFI standards as well as the respective jurisdictions standards. Then we have some of the requirements related to transparency and disclosure, particularly FAS 34 of AOIFI and the transparency and disclosure requirements of GS12. Sister Alia, I think GS12 also has the transparency and disclosure requirements, so we should create a reference to that one also. Then we have referred here to IFM's template documents also, because they also have some good transparency and disclosure requirements with regard to prospectus, etc. IFSB standard number 19 is important with regard to that. They have multiple standards on that, but particularly standard number 19 is very much relevant. Then we come to ethics and values. So we have to apply the AOIFI code of ethics and the code of conduct issued by IFSB and respective regulators code of ethics or code of conduct that they have issued. So those are to be applied. It has its own part. Then coming to the fiduciary performance and capacity. As I mentioned, it has to involve some of the assessment with regard to the quality of assets, the performance of the assets, the asset management quality of the originator and the service agent where applicable. The track record of the originator, etc., has to play a role in that. So these are the things which are to be included in these elements. And as I mentioned, that the credit worthiness element is very important in case of number one, the liability type sukuk. Number two, the sukuk with the quasi-equity sukuk with having a purchase undertaking. So depending on the nature of the instrument, different weightage need to still be assigned to the credit worthiness of the originator. So if a credit rating already is available with regard to that part, that can directly take place in this credit worthiness element. But if the credit rating separately is not available in that situation, the Sharia compliance and fiduciary rating has to take into consideration the weightage, this element separately, which will be done generally in accordance with the methodology applied for credit ratings. Maybe I'm still speaking too fast. As I mentioned, tiered and jurisdiction specific rating. So there are two approaches. One is the tiered rating. Tiered rating is that you apply the rating methodology and the benchmark parameters on a tiered basis rather than on an overall basis. So you can have the tiers of the elements. So you can keep it separate. Jurisdiction specific rating is that where AOIFI standards are not applied in a country and the institutions are not complying with AOIFI standards in general. In that situation, a specific methodology can be developed based on the local approach or considering AOIFI only as guidelines. And in that situation, the rating parameters may become slightly different, and accordingly, it will be called a jurisdiction specific rating. The relative weight of the benchmark parameters we have discussed, the rating scale elements we have discussed. So I think that we are reaching towards the end of the standard if I skip these sections, which I already briefly discussed with you. Now coming to the principal procedures part. The principal procedures we have covered in paragraph 37 to 54 of GS10, which provide the guidance with regard to the procedures. So we have covered those things already. So we have not repeated them in this standard because principally the same approach has to be taken to the principal procedure. Similarly, with regard to the documentation, archiving, and confidentiality, you need to fulfill the requirements which are there in GS10. So I would simply say that a lot of requirements were similar, so we kept them aligned. So both of these standards are to be read together, not independent. Now, coming to the reporting part. The reporting part, we have mentioned in the paragraph 61 and 62, and we have given some guidelines in that standard also with regard to the reporting. So that will be applicable. Now, coming to the effective date, the original effective date suggested by us when we issued the initial exposure draft, it was 1 July 2023. But I think that because the public hearings took a bit time, we have received some comments. The process is taking a bit of time. So I think that even 1 January 2024 would not be possible. It's my personal view that it may go to 1 July 2024. But we would love to have comments from the participants today or in writing going forward. With that, after that, we have basis of conclusion, etc., and other appendices. So I don't want to take you through these basis of conclusion, etc., but would love to have any comments if anybody has any comments. So with that, now the floor again is open for questions. Particularly, if anybody want to speak as well, they can take the permission to speak. There is one attendee who has raised hand, that is Brother Sadiq. So I request the team that he may kindly be allowed to speak. Yeah, we have coming from Turco scenario. I think the date of the effective standard shall be revised. We fully agree. What do you suggest? 1 July 24 or 1 January 25? What do you suggest, please? Comments for this standard are to be sent at governance@aoifi.com. For the accounting standards, we take comments generally on accounting@aoifi.com. For this one, we take comments at governance@aoifi.com. I think there are some comments going on the chat window. So the problem is that it is difficult for me to find all the comments. I can just find one comment. Can you kindly, Professor Ahmed Zai, can you kindly put your comments in the? Okay, he is just asking for the Dr. Ahmed Zai is just asking for the email address. Okay, for the accounting standard you can send. Or okay, thank you, Brother Rizwan. I cannot see. There were two hands raised, one by Brother Sadaq Khan, one by Brother Sadiq. Brother Sadiq, you are permitted to speak if you like. Brother Rizwan, yesterday there was a problem when we allowed people to speak. They were unable to use the mic. So if you can just kindly promote both of them, Brother Sadiq and Brother Sadaq Khan, to panelists, then maybe they will be able to speak. Because yesterday also this was having a problem. Dr. Alam Khan Ahmed Zai has suggested January 2024 should be the date. We take a comment of that. I'm still afraid that that by the time we finalize, the target is to finalize this standard within this year, but maybe maybe it may become immediately applicable because there are not too many things in the market. So from that perspective, it might be a good idea that we can allow it. So we can have it. We have a highly recommended approach for all the instruments to be rated under this. Obviously, highly recommended till the time it is not adopted by the respective regulators doesn't become applicable, but we have suggested that. So again, I think 1 January 2024 or 1 July 25 might be okay. 1 July 24 might be okay. We'll take your comment to the board, sir. Turco scenario has suggested for 2025 a year of transition period should be is comfortable. I agree with that. Only thing is that we do not have too many things in transition. So that's why maybe if we put up a date earlier also, that might be okay. But it's a good idea. And particularly for those countries who adopt our standard, it might be a good idea to start because it's highly recommended. So if we should start encouraging this thing. Okay, so there were two persons. Brother Rizwan, I requested you that you might need to allow Brother Sadaqat Khan and Brother Sadiq to be added to the panelist, because earlier I think that even yesterday somehow
You
there is
have
a
to accept the invitation.
Okay, okay. Because yesterday's, I don't know why this problem is happening, but yesterday also there were one or two people who actually wanted to speak, and we allowed them to speak, but it could not work. So we had, so they had to write their comments again. Okay, Brother Sadaqat Khan, you want to say something, sir? I think if nobody is putting any other comments and we don't have any questions or comments in the Q&A tab, I'll hand it over back to you, Brother Rizwan, with thanks to all the participants for today.
Thank you very much. I just want to check in terms of the issue. Brother Bolif, are you able to hear us well? Can you try and unmute yourself? Just wanted to say salam to you. Mr. Sadaqat, you wanted to ask a question as well.
Yeah. Can I speak now?
Yes,
Unmuted.
Yes, we can hear you,
yes,
sir. Now.
Brother Amar, thank you for your tireless and speedy presentation again. And surely this rating process will strengthen the confidence of the stakeholders or public and institutions and corporate entities on the Islamic Sukuks and other instruments, surely. But if the rating process is really actually implemented by the rating agencies, as you said that this is not the AOP area that they will allow or approve any rating agency. Instead, rating agency should be allowed by the regulators of that respective country. So as a whole, this standard will surely strengthen the confidence of stakeholders and in the Islamic finance industry and the Islamic capital market as well. So efforts from AOP are going on very well, and we all appreciate AOP's team members and other guys and all those who are participating and contributing into these improvements in the Sharia compliance level. Thank you very much. Thank you.
Thank you very much, sir. Thank you very much. Your comments are always very much valuable to us, and thanks for sparing time for these events. I think that we cannot agree more that this is actually the purpose to strengthen the confidence of the stakeholders. Just one thing I would like to mention, that while we do not have any, even before rating agencies, the issue of quality assurance of the Sharia auditors is there, the external Sharia auditors in particular, because now ratings are not that common still, but the external Sharia audit has started becoming common in certain parts of the world. So as of now, we are actually considering a possibility of creating a global quality assurance board in collaboration with the regulators. We can't do it alone, but we can consider taking collaboration of certain regulators from around the globe to have a quality assurance board. And that quality assurance board for external Sharia audit can be the starting point. If that works well, then with the help of the regulators, we can develop an additional quality assurance board for the rating agencies. This is something which is, to be honest, as of now, we have so many things in the plan, but we have so limited budgets and resources. that a lot of things that we are planning cannot happen. So it's very unfortunate for us that a lot of things are like with this quality assurance board for external Sharia audit. I think we are thinking and planning for more than 1 year, but because of the lack of resources, we are unable to take it forward. So this is something where I'm honestly looking forward towards the institutions represented here, that they need to support AOIFI's activities so that these type of initiatives we can take, which will eventually help the industry as a whole. So, and particularly the regulators represented here, I would like to mention that if they like, we can start talks on this. We have already talked to some of the regulators. They were positive about the idea of having a global quality assurance board, which can approve the quality assurance of the external Sharia auditors from around the globe. So there can be a mechanism and the methodology, and there can be a team working under this board. So this is something that we are here to serve the industry in the best possible way we can. But for sure, we are having a considerable lack of resources and constraints on the financial and human resources. So for which we actually want all of you to support us, regulators, institutional members, non-members of AOIFI, other institutions. We would request all of them to support some of our initiatives to be able to actually do these things. So if that experience we are able to do and it works well, probably we will be able to do a quality assurance board for the rating agencies as well. With that, I would like to thank you all. I just saw there is a comment from Brother Alam Khan Ahmadzai again. I think for Sukuk rating, AOIFI should come up with rating mechanism like we have Camel's rating for banking sector. Dr. Alam Khan Ahmadzai, actually, if you see, similar to Camels, we are not going to that Camels. Slightly, we have different methodology, but the benchmark, we have given the illustrative rating scale, as I mentioned, and we have given the illustrative allocation of benchmark parameters weightages. So I think we have given a reasonable detail, and this can serve as the starting point for the industry. But we do not want to give a fixed scale like Camel's rating. Camel's rating makes it a very fixed rule-based mechanism. That we believe will not be possible because we are a global standard setter, not a specific regulator can go for Camel's rating in their country because they have very set of very identified strict rules that apply to the banking sector. But from our perspective, we have to keep it flexible, and the rating agencies, if you see around the globe, they have their own methodologies. So if you want to bring in good rating agencies to do this function, you need to give them a reasonable level of flexibility, and that's why we have given the illustrative benchmarks, we have given the illustrative rating scale guidance, we have given the overall approach towards we have given this overall approach towards this distribution of benchmark weightages, etc., as well, and obviously the methodology and criteria and all these things we have given, but we have to give some flexibility like tiered rating and the jurisdiction specific rating, etc. So that Camel's rating thing might not apply in this situation. Brother Alam Khan wants to speak also on this. Brother Rizwan, if you can kindly allow him to speak.
Professor, you're allowed to speak if you can kindly unmute yourself. Oh, I wanted him to speak in here. Okay. Prof, you're allowed to speak. You can unmute yourself.
Assalamu alaikum.
Wa alaikum assalam. Welcome, sir.
Thank you, Ansari Sahab, for giving me opportunities, and thank you, Dr. Rizwan Malik Sahab. Actually, in my practice as a founder of Islamic banking in Afghanistan, I was always asked by the government, by the people, and by the international community and the donors that as a founder of Islamic banking, so you say that we claim that Islamic banking is the best solution provider to the banking sector. But again, their question was about the there is no specific like camel rating structure or mechanism available in Islamic banking. So as a UFI, what do you suppose, or do you propose to have the mechanism that is acceptable for everybody for Islamic banking sectors? Like in conventional bank, we have camels rating. So what should be for the Islamic banking sector?
Thank you very much, sir. Excellent comment. I think I partially answered this point, but I would come to more details. Sir, for example, when we are sitting as only one regulator, I know if I have adopted AAOIFI standards or I have not adopted AAOIFI standards. I know if I have issued some of the rulings of my central Sharia board or not. I know that I have a specific governance framework which may include AAOIFI and IFSB standards, and it may not. So if you ask me to develop a CAMELS rating for one country, I have worked with regulators, I have advised them on some projects, so I can tell you that I can tell you a long time back, my first major project in Islamic finance, nearly 19 years back, was developing a Sharia compliance inspection manual for a central bank. So you can understand that I have understood that concept of applying camels and all that at that time when I was very young. Now, it's after nearly 2 decades that we are talking. So from that perspective, I can tell you that doing a Sharia camels, again, camels obviously has some of the elements which are more on the more on the on the quantitative side and the number side. I believe that the methodology of rating that we have on the institution side, that today what we are seeing is on the instrument side. On the instrument side, even the first column was actually mentioning the references that are there in GS10 with regard to the institution. We believe all of these elements are to be considered while developing the criteria for CAMELS rating, and we can do that. But the question is, we are here talking about a global standard setting body developing standards for the global audience, which means that Bahrain may adopt all my standards and maybe Pakistan may adopt partially my standards, and Afghanistan may adopt all my standards, but Afghanistan may have their own, some of the Central Sharia Board rulings as well. Now, the point is that when I try to apply this thing as AOP, I cannot do that. Second thing, the pure regulatory function is not in the mandate of AOP. It is in the mandate of IFSB. And even I understand that IFSB do not want to go in those minute details because, again, being a global standard setter, they also have to look after the same considerations that we have, that we need to develop such principle-based standards that can be applied. Like, if you like these principles, you can try to apply them as maximum as possible as it is. But there can be some situations where you need to apply the local regulations and the local elements, etc. So considering this thing, AOP and IFSB generally develop principle-based standards, but AOP goes in more detail as compared to IFSB. And as I mentioned, that the pure regulatory supervision and regulatory functions are not part of AOP's mandate. They are part of IFSB's mandate, and we respect that mandate, and we believe they are doing a good job in that area. And we try to reciprocate each other, try to work together with each other. In this standard, even you might have seen that we have created multiple references to IFSB standards. And I think this is the right way of working together for the benefit of the industry. So from that perspective, sir, I would submit that CAMELS rating, number one, would be country specific only. It cannot be set up by something similar to CAMELS cannot be set up by AOP on a global level. Secondly, it's not part of our mandate. So even if it is possible, that it is possible in the hand of IFSB, not us. What we have provided might provide a good basis for even the regulator to determine their own, assessment criteria.
Thank you.
Thank you very much, sir. Thank you very much.
And one thing additional that Mr. Omar Mustafa Ansari said, we are here in California, USA, and there is a lot of time difference. So
We
it is
appreciate
now,
it, sir, that you
it
are
is
taking
now
your
just,
personal time out for this.
yeah, 1:20 a.m. So it's
Yeah, I
more
was
than
going to ask you
midnight.
the time actually.
Yeah.
So Allah bless you.
Uh,
It's jihad. We pray for you.
Okay, thank you. And the second thing is that I was not invited to yesterday event. And the third thing is that please
For
send me
just for the yesterday event, we will try to make sure that you are included in all our mailing lists, because at times it might be missed out by our team, that because we have multiple mailing lists. So I would request the team to make it happen every time. Secondly, on the yesterday's standard, I think there will be one more public hearing. So I will request our team particularly to inform you that with regard to the yesterday's standard, the next public hearing date should be informed to you in advance, sir.
Okay.
And
And
the recording of the session is available on YouTube.
yeah, can you send me the link?
Sure.
Okay. Thank you. Ansari Sahib, the last request of me is to please make sure to send the standards at least 3 days prior to conduct the meetings. I may have enough time to study and then come with my full comments.
Thank you very much. We make a note of it, Brother Rizwan. Do we put a link of the standard also on the invitation?
Yes.
Okay, sir, the invitation actually contains that, but we'll make sure in your case particularly, because we always admire your very valuable comments. So I would request the team particularly for those experts who are giving more time and becoming more focused. Again, it applies to everybody, but as you have requested, so we'll try to make sure that the team actually make sure that you get it in advance. These are always available on our website. You can whenever you have time, you can have a look at our website, which exposure drafts are available. You can do your review in like your suitable times. Whenever the public hearing is there, you can provide comments. But these are always available. I would request the team to provide you a link to all the exposure drafts which are already available as of now. Some of them you might still prefer to send comments in writing. We'll highly appreciate that, sir.
I would request everyone to subscribe to AAOIFI YouTube channel as well. I think it gives an automatic notification. It sends out an automatic notification whenever there is a public hearing or an event that is going on. So that is just in addition to
excellent idea, Brother Rizwan. I think it's an excellent idea because it will make sure that you get something. Thank you very much. This is excellent.
Additionally, Professor, I know California is 7 seas apart in terms of time zones. But generally, we try and ensure that we organize public hearing for different time zones. So given that today's focus in particular was for Far East, and given that it's afternoon already for them, we organize it this time. Sometimes we try and organize it in the later half of the day for in Bahrain to target some of the European markets as well as some of the Middle Eastern markets and the Western Hemisphere in that sense. So we try and cater for that, but for California time zone, I mean, I think it's going to be a challenge for most of the time. So we would request, your support and kind understanding in this. We may get to a point that we may organize dedicated public hearing just for that region in due time, hopefully. In that case, I think we will have to take care of some of our late hours or early hours. So inshallah, we'll try and do that.
Thank you, brother.
Sadaqat Sahib, it's good to see you. And with that, I would like to thank you all. And Brother Rizwan, I think you can close now.
Yeah, just before I go, Brother Borif, are you able to hear me? Can you unmute your mic just for a minute? Or any of the candidate who can, maybe Brother Adnan Shafi? Okay, we'll look at it at our end anyway. Okay. Thank you very much, Brother Umar, for taking all the stakeholders through the very comprehensive standard. Certainly, this was the second public hearing on this exposure draft. There will be at least 2 more public hearings in English on this standard, as well as 1 in Arabic. So there will be 3 more public hearings to come for this session. Once again, I request you all to please, sign up to AAOIFI mailing list as well if you haven't, and to AAOIFI YouTube channel if you have not signed up already. This will just continue to send you notification as and when there are some events or announcements made. So that's from that perspective. If you still wish to send in some comments in writing, please do that at governance@aaoifi.com for this particular exposure draft. On behalf of AAOIFI and our partners for this conference, for this public hearing, KNEKS from Indonesia, other advisory, Salihin Sharia Advisory, and ISRA NCF, ISRA RMC. We would like to thank you very much, for joining us for this session. We look forward to welcoming you at the future sessions. And until then, you look after yourself, and Assalamu alaikum wa rahmatullahi wa barakatuh. I'm putting in AAOIFI YouTube channel link for those who are still around. Please click on this.